Good evening, everyone. I am Ronelyn Medinilla, the chairperson of this tribunal, with the first member of this tribunal
Meling Dalagan Esparago,
and the second person of this tribunal.
Marilo Cabilon Torres.
We are here for our second hearing regarding the dispute of ISE and Verbe Senior Engineer Ltd. Against the Senado Universal Technologies. As we all know, during our first hearing, the Council of Senado maintained its position that this tribunal should discontinue to conduct this proceeding. Now I want to hear the position of ISE.
The honorable members of the tribunal, good evening. I am Marcos Ricaplaza, the counsel for Verbe Senior Engineers Limited. As you mentioned a while ago, that during our first meeting, the counsel for XUT, there was a move from them that the proceedings should be stopped, which according to them, this tribunal doesn't have any jurisdiction regarding the case. I have issues regarding the request of XUT. First, I want to raise that there was valid contract in the first place. Although there were issues that during the tender, the building proposed by IEC was 540 inches tall, which is around 45 feet. And during the construction, XUT found out that the building supposed to be 540 feet and not 540 inches, which obviously it's not the fault of my client. The contract was signed and it was valid. It was the duty of XUT to verify whatever the requirements of the royal family of the Kingdom of Senado. And they failed for that one, and the contract was signed. As I've said, there was a valid contract in the very beginning. So what happened? XUT, they stopped all the payments. And I want to raise that with a signed contract agreement with XUT and IEC, there were also provisions for arbitration. We've got the 3 articles there, the 43, Articles 45, and Articles 44, which according to Article 45, let me read what it is. Parties shall resolve any disagreement by a peaceful negotiation between the parties and undertake to attempt settlement of all disagreement in good faith. And based on our records, the CEO of IEC, he exhausted all means to reach XUT. He made a lot of phone calls, he sent official notification that he wanted to discuss what's going on. Although there was a response from XUT, but the issues were never resolved at all. So by virtue of Article 44 of the Arbitration Agreement, which states that any dispute arising out of this contract, including the existence, validity, interpretation, performance, breach, or termination thereof, not resolved in accordance with Clause 45 above, shall be referred to and finally resolved by arbitration by the Hong Kong International Arbitration Center. And the seat of arbitration shall be in London, England. The number of arbitrators shall be 3. The arbitral proceedings shall be conducted in English. All of these provisions were being complied by IEC. So I really don't see the issue why we should stop the proceedings, because we believe that this tribunal has jurisdiction to the case. Although in the kingdom of Senado, there are sectoral laws which provide restrictions between the businesses of the royal family, and according to them, according to that law, that these businesses cannot be arbitrated. I want to cite the article 2, Section 1 of the New York Convention 1958, which states that each contracting state shall recognize an agreement in writing under which the parties undertake to submit to arbitration all or any difference which have arisen or may arise between them in respect of a defined legal relationship, whether contractual or not, concerning a subject matter capable of settlement by arbitration. As per this convention of New York Convention of 1958, it's very clear that the kingdom of Senado, the royal family, can be a party to the arbitration agreement. And further, in Section 106 of Arbitration Act of 1996, the Crown can also be a party to an arbitration agreement. So this doesn't exclude the royal family of Senado not to be a party to arbitration agreement. I want to cite a case between Savinsky Petroleum Exploration and Lithuania. And in that case, Lithuania imposed restrictions regarding dispute for natural resources. But on that case, the court held that even though there were restrictions regarding the disputes, Lithuania can be a party to arbitration agreement. So this only proved, again, that the royal family of Kingdom of Senado, having ownership of these businesses, can also be a party to the arbitration agreement. And as per the New York Convention 1958, I want to cite some cases regarding the doctrine of separability. That although the effect of the rule that is unenforceable of the underlying agreement does not automatically render an arbitration agreement contained within it unenforceable. This was cited in the case of Harbor Assurance and versus Kansas General International Insurance. So you cannot exclude the case between the Kingdom of Senado having the excuse that there were sectoral laws in their country that you cannot arbitrate their businesses. So I hope in good faith that this tribunal will hear the issues that I raised and be fair and reasonable. Thank you.
After hearing the positions of both sides, this tribunal will convene and decide regarding the jurisdiction of this claim. This hearing is adjourned.
Okay, thank you.